So we had left off with a preview of one of the rights which both as a citizen and as a lawyer, I believe embodies and complements the right of defense, giving full effect to the principle of transparency and good administration. I mean, the right of access to documents. Well, Regulation number 1049 of the 30th of May 2001 governs public access to documents of European Parliament, the Council and the Commission, with the aim of ensuring through greater transparency, better citizen participation in the decision-making process and enhancing the legitimacy, efficiency, and accountability of the administration towards citizens in a democratic system. The principle of transparency is enshrined in the second paragraph of Article 1 of the Treaty on the European Union, according to which decisions must be taken as openly as possible, and is further reaffirmed by Article 15 of the Treaty on Functioning of the European Union, which requires the institutions, bodies, and agencies of the Union to operate as transparently as possible. Holders of the right of access are Union citizens and any natural or legal person residing or having its registered office in a member state. The subject of this right includes documents consisting of any information content, regardless of its medium, paper, electronic, audio, video, recording, relating to policies, initiatives, and decisions within the competence of the European institutions. The application must be submitted in writing, including electronically, with sufficient precision to allow identification without the need for the applicant to provide reasons. With the maximum period of 15 days from the request, the institution shall either grant access in practice or refuse it in whole or in part with a reasoned written reply. So, to facilitate the exercise of the right of access, each institution is required to make directly accessible to the public an electronic register of documents, which for each document contains a reference number, the subject, and or a brief description of its content, as well as the date on which it was received or drawn up and entered in the register. The founding treaties in their original formulation did not recognize the citizens of the member states' right of access to the acts of the institutions. And this omission was justified by the institutional model then in place, which conferred on the community bodies far more limited regulatory and administrative powers than today. And in particular, the Treaty of Rome did not confer upon community law either the capacity to directly affect the legal position of the citizens of member states or supremacy over national law. Moreover, the community was established without its own administrative apparatus. So the founding fathers envisaged that the implementation of community policies would rely on the administrative structures of the member states. So the evolution of the union system is too well known to be retracted here, and the expansion of regulatory competences into ever broader areas, together with the recognition of the principle of direct effect and supremacy of community law over national law, made it necessary to ensure the application of the democratic principle within the Union. And furthermore, the development of the Union's regulatory powers was accompanied by the progressive establishment of a European administrative apparatus, with increasingly significant powers also vis-à-vis the citizens and enterprises of the member states. So it is therefore not by chance that when the strengthening of the process of European integration highlighted the issue of the Union's so-called democratic deficit that we analyzed in the previous lesson, the need arose to render the institution's activities more open, more transparent. The recognition of Union citizens' right of access to documents enables better knowledge of the functioning of public authorities. So in this light, the right of access is linked to the so-called passive aspect of freedom of information, namely the freedom to seek and receive news and information, and it strengthens the democratic character of the Union. From another perspective, the reinforcement of administrative powers conferred on the European institutions made it necessary to ensure that the persons concerned could effectively protect their interests in administrative proceedings. Hence, the recognition of the right of access to documents as an instrument of participation in administrative procedures and as a precondition for the effective exercise of the right of defense against unfavorable measures. So, in the Union system, however, the right of access is not conceived solely as a tool for participation in administrative proceedings. Access may also be exercised for the purpose of overseeing the activities of public authorities when they perform administrative or regulatory functions. It does emerge as a substantial difference with respect to the way in which the right of access is guaranteed, for example, under the Italian legal system. Part of Italian legal scholarship has acknowledged that with the entry into force of the Republican Constitution, the right of access finds its foundation not only in the principle of good performance and impartiality of administrative action enshrined in Article 97 of the Italian Constitution, but also, and even earlier, in the principle concerning freedom of information inferred from Article 21 of the Italian Constitution. So, despite this authoritative framework, however, the need to avoid organizational problems for the public administration led the legislator to restrict entitlement to exercise the right of access solely to those subjects who have a direct, concrete, and current interest corresponding to a legally protected situation and connected to the document to which access is requested, and to establish that the request for access to documents must be reasoned. As a result, the general principle of transparency of administrative action, although expressly recognized by the law on administrative procedure, is in fact limited in such a way to prevent the possibility of a generalized oversight of the activities of public authorities, which the principle of transparency should otherwise allow. So overall, therefore, the Union system protects the right of access to the acts of public institutions more broadly than was the case in Italian legal order, to the point that provisions have been introduced into the Code of Administrative Procedure precisely in order to comply with the principle of transparency and good administration enshrined in the Charter of Fundamental Rights, which, as we know, has the same legal value as the treaties and must therefore be respected and immediately implemented. But let's take a closer look at the regulatory evolution regarding the right of access to the documents of the Union's institutions. The first community document concerning transparency is Declaration number 17, annexed to the Treaty on the European Union of the 1992. In this act, the conference emphasized that the transparency of the decision-making process strengthens the democratic nature of the institutions and the public's confidence in the administration, and recommended that the Commission present to the Council by 1993 a report on measures intended to increase public access to the information held by institutions. So the call for strengthening the transparency in the community decision-making process was subsequently reiterated by the European Council at its meeting in Birmingham, in Edinburgh, and in Copenhagen between the October 1992 and the June 1993. In line with the position expressed by the European Council, the Council and the Commission approved on the 6th of December 1993 a code of conduct concerning public access to documents in their possession. So the principles laid down in the code were implemented by the Council with decision number 93 731 of the 1993, and by the Commission with decision 90 of the 1994. The Court of Justice called upon to rule on the legality of the framework introduced by the Code of Conduct and decision number 731 of the 93, identified the legal basis of that framework in the power of internal organization of the community institutions. In this judgment, the court therefore excluded the existence of a general principle of community law guaranteeing access to the Institutions Act, as had instead been argued by Advocate General Tesauro. And at this stage, therefore, each institution was deemed free to decide whether or not to recognize the right of access to its documents and to establish its limits. Despite having embraced such a restrictive interpretation of community law on access, the Court of Justice nonetheless stressed that the internal regulation of the majority of member states now generally enshrines as a constitutional or a legislative principle the public's rights of access to documents held by public authorities, and that at the community level, the importance of this right has been repeatedly reaffirmed, in particular in Declaration on the Right of Access to Information, which appears in Annex number 17 to the final act of the Treaty on European Union, linking this right to the democratic character of the institutions. So these statements does foreshow the future development towards the full recognition at the community level of the right of access. The Treaty of Amsterdam, while constituting a step forward in this direction, did not go so far as to enshrine the existence of a general principle of access to the acts of European institutions. The treaty, after affirming that the institutions must act in compliance with the principle of transparency, recognized for citizens and residents of all member states a right of access to documents of the European Parliament, Council, and Commission. However, the regulation of the exercise of this right was deferred to a specific regulation containing the general principles and limitations on ground of public or private interests, and each institution retained the power to lay down specific provisions on access to its documents and its rule of procedure. So the regulation number 1049 that I mentioned before gave effect to the provisions of Article 255 of the treaty, defining the scope, limits, and procedures for exercising the right of access to documents of the European Parliament, of the Council, and the Commission. The regulation attached a central importance to the principle of transparency, expressly recognized by Article 1 of the treaty, since that principle ensures greater participation by citizens in the decision-making process and guarantees greater legitimacy, efficiency, and accountability of the administration towards citizens in a democratic system. So the regulation does shape the right of access as an instrument to guarantee institutional transparency and to reinforce the democratic principle. And in this perspective, it sought to give the fullest possible effect to the right of public access to documents, eliminating the restrictions on its exercise as far as possible. And in particular, the regulation provided, among other things, that requests for documents do not require the demonstration of specific interest, and therefore applicants are not required to state reasons for their requests. Institutions may refuse access only under exceptional circumstances, in particular where disclosure would undermine the public interest, privacy and integrity of the individual, the commercial interest of a third party, court proceedings or inspections, or the institution's decision-making process, unless there is an overriding public interest in disclosure, following Article 4. So, the regulation number 1367 of the 2006 concerning the application of the provisions of the Aarhus Convention to community institutions and bodies further strengthened the right of access to documents of the community institutions in environmental matters. In this field, indeed, the right of access was granted to any natural or legal person, irrespective of citizenship or country of residence, and its exercise was extended to documents of all community institutions and bodies, whereas regulation number 1049 applied only to Parliament, Council, and Commission. And moreover, with regard to environmental information, the regulation required a restrictive application of the exceptions provided for in Article 2 of the Regulation 1049. A further strengthening of the community right of access came with the entry into force of the Treaty of Lisbon. Article 15, which replaces Article 255, first, it reaffirms the principle of transparency already recognized in Article 1 of the treaty, providing that the institutions, bodies, and agencies of the Union must operate as openly as possible. So the provision also extended the right of access to all documents of the Union's institutions, bodies, and agencies, whereas the former Article 255 of the treaty limited access only to documents of the Parliament, the Council, and the Commission, as I said. So the provision entrusted the definition of the general principles and limitations of the right of access to a regulation adopted by European Parliament and the Council, which each institution, body, or agency must comply with in defining access to its own documents. A special regime was laid down for the Court of Justice, the European Central Bank, and the European Investment Bank, with respect to which the right of access to documents under Article 15 applies only when they exercise administrative functions. So the right of access is also guaranteed by Article 42 of the Charter of Fundamental Rights, which provides that any citizen of the Union and any natural or legal person residing or having its registered office in a member state has a right of access to documents of the Union's institutions, bodies, and agencies, regardless of their medium. As is well known, Article 6 of the treaty conferred upon the Charter of Rights the same legal value as the treaties. So the Treaty of Lisbon thus represents the culmination of a process that has led to an ever greater recognition of the right of access to institutions' documents. And a clear change is evident compared to the initial phase, in which recognition of the right of access was regarded as an autonomous choice that each institution could make it in the exercise of its internal organizational powers. So, union law recognized the need to guarantee as widely as possible transparency and the right of access when public institutions act in their legislative capacity. From this perspective, case law has interpreted restrictively the limits so that in order to protect other relevant interests may justify refusal by European institutions to disclose documents relating to legislative procedures. Well known in this regard is the Guardian case, in which the Court of First Instance held for the first time that the principle of transparency aimed at ensuring broad public access to institutional documents requires a strict interpretation of exceptions to that right. In that case, a journalist had requested from the Council a number of documents concerning certain legislative procedures. The Council had rejected the request for access, justifying the refusal with a simple reference to Article 4 of the decision 731 of the 97, which provided that access to a Council document may be refused in order to protect the confidentiality of the Council's deliberations. The Court of First Instance, however, held that the Council, when exercising the discretion conferred on it by that provision, must actually balance, on the one hand, the citizen interest in obtaining access to its documents, and on the other, its possible interest in protecting the confidentiality of its deliberation. So, on that basis, the court annulled the refusal of access, holding that the Council had failed to demonstrate that it had carried out a prior balancing of the conflicting interests at stake. The restrictive interpretation of exceptions to the right of access was confirmed in subsequent case law, particularly noteworthy the judgment better known as the Turco case, in which the Court of Justice overturned the judgment of the Court of First Instance that had considered legitimate the Council's refusal to grant access to a legal service opinion concerning a draft directive. So, the Court of Justice in that case did not accept the Council argument endorsed by the lower court that access to the legal opinion on the draft directive could cast doubt on the lawfulness of the legislative act concerned. The court considered instead that transparency, by enabling open debate and different point of view, contributes to increasing the legitimacy of the institutions in the eyes of the European citizens and to enhancing their confidence. And furthermore, the court held that the risk relied upon by an institution in order to refuse access must be reasonably foreseeable and not purely hypothetical. So the court also excluded the possibility that the independence of the legal service could be endangered by disclosure of its opinions, adding that in any event, disclosure is justified by an overriding public interest, the need to guarantee transparency in the legislative process. So recognition of the existence of an overriding public interest requiring access to documents therefore implies that as a general rule, no act in the legislative process may be kept secret. So this judicial orientation in favor of broad protection of the right of access was confirmed by the recent judgment of the Court of the First Instance in the Borax case. And the action was brought by a company producing borax and boric acid, and the Commission called upon to determine whether those products should be included in the list of dangerous substances contained in Annex 1 to Directive number 548 of the 1967, had relied on the work of a group of national experts who concluded that substances must be classified as hazardous to pregnancy. So the Commission rejected the request for access to the documents relating to the work of group of experts on the grounds that their disclosure would have violated the confidentiality which the Commission itself had guaranteed to the experts, and that by exposing them to undue external pressure, disclosure could also have undermined the decision-making process in the matter. But the Court of First Instance annulled the refusal of access, holding that the Commission had failed to demonstrate that disclosure entailed a concrete risk and not merely hypothetical of prejudice to the interests protected by Article 4 of the Regulation 1049. So it is therefore not sufficient to invoke the need to protect confidentiality or the potential harm to the decision-making process in order to justify refusal of access. And rather, actual proof must be provided that disclosure entails a serious and concrete risk of harm to the protected interest. So, the Union system recognizes a broad right of access to the acts of administrative procedures. In particular, access to such acts is not subject, as in the case under the Italian system, for instance, to the requirement that the applicant demonstrate a direct, concrete, and current interest corresponding to a legally protected situation and connected to the document request. So access may therefore also be exercised solely for the purpose of monitoring the conduct of the public administration, unless the disclosure of a particular document would infringe interests protected by the law. And in practice, the right of access, however, to the acts of administrative procedure is subject to more extensive limitation than those applicable to the legislative procedures. In its judgment, My Travel case, the Court of First Instance stressed the distinction between cases in which the community institutions act in their capacity as legislator, where broader access to documents should be ensured pursuant to the 6th recital of Regulation number 1049, and those which instead fall within the framework of the Commission's purely administrative function. And in particular, the Court observed that the public interest in obtaining the communication of a document under the principle of transparency aimed at ensuring a greater citizen participation in the decision-making process and guaranteeing a greater legitimacy, efficiency, and accountability of the administration towards citizens in a democratic system does not carry the same weight for a document falling within the scope of an administrative procedure relating to the application of merger, control, or competition law in general, as it does for a document relating to a procedure in which the community institution acts as legislator. So, In this perspective, the court upheld the Commission's refusal to grant access to the reports of a working group established to assess the advisability of appealing against the Air Tours judgment in the field of mergers. And the court considered that the disclosure of such documents would in itself create a serious and concrete risk of undermining the effectiveness of the Commission's enforcement of competition rules. And the conclusion of my travel judgment were confirmed by the Court of Justice in another case, the TGI case, concerning a procedure relating to the application of state aid rules. In that case, a company recipient of a state aid which the Commission had declared unlawful was denied access by the Commission to the documents in the control procedure. The Court of Justice, overturning the ruling of the Court of First Instance, stressed that unlike cases in which the community institutions act in their capacity as legislator, where broader access to documents should be authorized, the documents relating to state aid control procedures, such as those sought by TGI, fall within the scope of the administrative functions specifically concerned and conferred on those institutions. So the court held that access to the file of state aid procedure may be granted only to the member state responsible for granting the aid, since if access were extended to other parties, the state aid control system would be called into question. So it therefore follows that there is a general presumption that in state aid control procedures, disclosure of the documents in the administrative file may in fact prejudice the protection of the objectives of the investigation activities. However, this is a rebutable presumption which does not exclude the right of the parties concerned to demonstrate that a particular document request does not fall within that presumption, or that there is an overriding public interest just justifying a disclosure of the document in question under Article 4, Paragraph 2 of the Regulation 1049. Well, the principle of confidentiality, according to the above-mentioned case law, characterizes proceedings aimed at the application of the competition rules significantly limits the exercise of the right of access. This is a general limitation linked to the convention, whether right or wrong, that the disclosure of documents in the proceedings could jeopardize the achievement of the objectives of the investigative activity. By contrast, there are no decisions linking the refusal of access to the applicant's failure to demonstrate entitlement to a specific qualified interest connected to the request document. The cases I mentioned, therefore, do not exclude that the right of access may be exercised for the purpose of monitoring the conduct of the public administration. And even in such cases, however, access may be denied only if disclosure of the request document would concretely entail a risk of prejudice to another legally protected interest. So the interests which may justify limiting the exercise of the right of access to the documents of an administrative procedure are numerous. By way of example, one may recall the need to protect personal data, the confidentiality of examination board activities, or the protection of professional secrecy. And we can say that despite these limits, union law conceives access not only as participation and defense, but also as a democratic guarantee of transparency. And in this regard, the Court of Justice has stressed that the democratic principle requires transparency in the work of public institutions and that access by allowing different points of view to be openly debated contributes to increasing the legitimacy of the institutions in the eyes of European citizens and to enhancing their confidence, as I said before, whereas a lack of information and debate may generate doubt among citizens not only as to the legitimacy of a particular act, but also as to the legitimacy of the decision-making process as a whole. So as we have seen, the Treaty of Lisbon introduced new provisions designed to broaden the exercise of the right of access in order to enhance the transparency of the public authorities and the possibility for citizens to oversee their conduct. So, the access procedure begins with the applicant's request submitted in writing, including electronically, and the request does not need to be reasoned since, as noted, the purpose of the right of access is to guarantee democratic oversight of the work of institutions rather than to protect the legally relevant interests of individuals. So the request must, however, be sufficiently precise to allow identification of the request document. Otherwise, an informal dialogue is initiated between the citizen and the institution in order to identify the object of the request. The maximum time limit for the procedure is 15 days, within which the institution must either grant the request and provide access by on-site consultation or by releasing a copy, or reject it by means of a reasoned written response. Appeals against the total or partial refusal of access or against the institution's failure to respond consist of two stages. The first administrative, the second judicial. First, the applicant must ask the institution to review its position by submitting a confirmatory application. Following this review, the institution may decide either to grant access or to confirm the refusal. In the latter case, it must provide reasons for its decision and inform the applicant of the means of redress available, namely judicial proceedings against the institution and or the possibility of lodging a compliant with European Ombudsman. Regulation number 1049 also governs certain instruments designed to facilitate and encourage access to documents. First, it provides for the creation within each institution of a register of documents, namely a catalog, generally accessible in electronic format, containing the details of the documents produced by the institution. And it is further established that, as far as possible, documents must be made directly accessible, either through the catalog or electronically. Otherwise, the catalog must indicate where the document can be found. And finally, each institution must inform the public of the existence of the right of access and of the procedures for exercising it. The regulation, however, does not limit itself to regulating access or request, but also contain a provision extending the range of access subject to publication in the official journal of the European Union. The types of acts covered seem to indicate the intention to enhance the transparency of community legislative process and of all union decision-making processes, including those still based on forms of intergovernmental cooperation among member states. In this perspective, publication was mandated for Commission proposals, the position taken by the Council and the Parliament in cooperation and co-decision procedures, acts of the third pillar, and international conventions. And this provision seems to emphasize the role of administrative transparency as a guarantee of responsiveness, or better still, as an instrument capable of ensuring that each entity, institutions, and member states is held accountable, at least politically. So, the right of access to the acts of the institution of the European Union following a 30-year evolution has reached a significant degree of maturity and can be reconstructed as a genuine right of citizenship enforceable before the Court of Justice. Indeed, access to documents is not intended to protect one's individual legal position and therefore does not require proof of specific interest. Rather, it stems from a general principle of transparency in union action and is an instrument of democratic oversight of the conduct of the European administration. And in this sense, it is aimed at providing a service to citizens and businesses, encouraging their participation and promoting an open and transparent administration. And nonetheless, the interaction between the national and the European level raises critical issues, both with regard to the application at the national level of union rules on access to documents and in relation to possible differential treatment of the same data at the national and European levels. Although no member state is obliged to disclose information, the release of which would be contrary to its essential security interests, in practice, this safeguard is difficult to apply as it may easily conflict with the principle of sincere cooperation, that is one of the fundamental principles of union law. And the problem is particularly felt by national administrations concerned about possible repercussion at domestic level of the European-wide disclosure of information that may or may not be accessible at the national level. So this can also be explained in light of the fact that there may be other parties involved with respect to documents requests. To address this issue as regards the balancing in the techniques between the right to information and the interest limiting it, union law provides the harm test and the public interest test. The first requires the European institution to assess whether disclosure would entail specific, concrete, direct, and highly probable harm to protected interests. The second, the public interest test, which is specifically the focus of what we are saying, may, in general terms, be understood in two different forms. In the first sense, the public interest test requires the institution to consider not only the harm to protected interests, but also the harm resulting to the public interest in knowing the information. Accordingly, access should be denied only where the harm to the protected interest is more serious and more probable than the harm to the public interest. Thus, the public interest, whether characterized as administrative transparency or the promotion of public debate, functions here as a driver of access to information held by public authorities. In the second sense, more aligned with a functional perspective, the public interest test serves to functionalize the right of access in relation to a public purpose. And accordingly, irrespective of the potential harm disclosure may cause to the protected interests, access is not permitted where the request information by its nature and content is not capable of fulfilling a public interest objective. So in this case, the institution is not required to assess the potential harm to the public interest resulting from non-disclosure, but rather to assess whether the information is suitable to satisfy the public interest. So it is evident in these terms that the public interest test becomes an instrument capable of broadening the margin of discretion of the institution and secondly of the court, enabling the examination of the content of the information and its potential collective use. Well, Article 4 of the European regulation provides for three different types of exceptions. In particular, paragraph 1 of Article 4 identifies absolute exceptions, stipulating that access must be refused where disclosure would cause actual harm to the protection of a public interest, for instance, public security or defense, military matters, international relations, or the financial, monetary, and economic policy of the community or of a member state, or of private interests as well, privacy and integrity of an individual. Paragraph 2 sets out relative exceptions, stipulating that access must be refused where disclosure would harm the protection of certain secondary interests. And in these cases, the relative nature of the exceptions lies in the fact that when actual harm is established, the institution cannot directly deny access, but must carry out a balancing test between the interest, public or private, protected, and by the exception and the exclusively public interest in disclosure. Where the latter prevails, the institution may not refuse access. And finally, paragraph 3 identifies an exception linked to the internal nature of documents, aimed at safeguarding the final decision. And even in such cases, access must be denied where disclosure of the document would seriously undermine the institution decision-making process, unless there is an overriding public interest in disclosure. So a balancing test is necessary between the protection of the independence of the decision to be taken and the possible overriding public interest in disclosure. So, we can say that in essence, a regulation provides on one hand for a series of absolute exceptions, where the sole criterion for application is actual harm to interests deemed of higher rank, and on the other hand for categories of less important interests, where the criterion of actual harm is tempered by the obligation to balance it with any overriding public interest in disclosure. Thus, only for the application of the relative exceptions under paragraph 2 and 3 that I mentioned, are European institutions required to carry out a comparative assessment among interests, which must necessarily proceed in 3 stages, corresponding to 3 criteria set out in that provision. And I mean a classification of the request document within a protected category of interest, determination of actual reasonably foreseeable and not purely hypothetical harm to the protected interests, and only upon positive finding of such harm, verification of the absence of an overriding public interest justifying disclosure. So, the affirmation of the right of access at a supranational level raises the problem of identifying the legal nature of the claim to information and of concretely defining the subjective legal positions connected to the right of access. On the one hand, there seems to be an affirmation of the right to know as a fundamental right of the individual to demand any non-confidential information corresponding to a duty on the part of the authority. So, in other words, a full recognition of the individual's freedom to draw upon administrative information protected as a fundamental right. On the other hand, some interpretations tend to qualify the right of access as instrumental to the right to knowledge, protected only insofar as there exists a public interest in disclosure. So, it is worth making a final brief reference to a recent ruling of the Court of Justice delivered by order on a question referred by the Italian Court of Italian Council of State. The recent order of the Court of Justice of the European Union addresses the issue of balancing the right of access to tender documents with the protection of trade secrets in the context of public procurement. Although delivered with reference to Legislative Decree number 50 of the 2016, the ruling has also a significant impact on another Italian law. And in particular, the Italian Council of State referred to the Court of Justice the question of the compatibility of national legislation, and specifically an article of the law, with so-called procurement directives. So the cited provision, while recognizing the protection of trade secrets, allowed access to such information by the excluded bidder where it was necessary for judicial defense. So Article 53, paragraph 6 of the Italian law established the prevalence of the excluded bidder's defensive interest over the economic operator's interest in the protection of trade secrets, but did not provide balancing mechanism aimed at safeguarding the need to protect the technical and commercial secrets of a successful tenderer. So the issue arose in the context of a tender for design, construction and commissioning of a plant for the electrical supply of cruise ships and other vessels in various parts of Sardinia. Two competitors participated in the tender, and the runner-up requested access to the successful bidder's tender documents, but the contracting authority denied access to parts of the technical offer containing, according to the latter, technical and commercial secrets. So the runner-up challenged both the award decision and the partial refusal of access, and the Regional Administrative Court for Sardinia partially upheld the runners-up request and ordered the disclosure of the successful bidder's technical offer. And the latter appealed this decision to the Council of State, acting as the referring court. The Council of State questioned the compatibility of the Italian access rules with the procurement directives, and in its referral order, it observed that the dispute concerned the disclosure in whole of successful bidders' technical offer. While the runner-up has an interest in accessing such an offer in order to identify and develop objections regarding the score awarded by contracting authority to the winning technical solution, access to trade secrets may also lead to an initiative imitative use of the documents, not to ensure the protection of the excluded bidder's rights, but rather to obtain information about a competitor. So, in this respect, the Council noted that Italian law provides that such access may be may be granted to the bidder for defense of its interests. And this provision would therefore establish the relevance of the so-called defensive access over the protection of trade secrets. So also the referring court further pointed out that according to Article 41 of the Italian Constitution, and the freedom of economic initiative is protected subject to the condition that it does not conflict with other values, among which are the inviolable rights of the individual under Article 2 of the Constitution. And these include the right to judicial protection enshrined in Article 24 of the Italian Constitution. So the Council also stated that according to the case law relating to Article 21 of the Directive number 24, the court confirmed the need not to disclose trade secrets, while at the same time emphasizing that such protection must be implemented in a manner reconcilable with the requirements of effective judicial protection. So In this respect, the court had recognized that member states enjoy a margin of discretion in determining the modalities of such balancing. So, in this field, the Court of Justice held that the prohibition on disclosing confidential information, including the technical or commercial secrets, that must be reconciled with the requirements of effective judicial protection. Article 39 of the directive does not prevent national legislation from providing for balancing between confidentiality and other legitimate interests, including access to information. So national rules cannot impose unconditional access, but must enable contracting authorities to balance the right to effective judicial protection against the need to protect technical or commercial secrets. So, in essence, according to the court, the right of access to confidential information, including technical and commercial secrets, aimed at ensuring the effectiveness of the applicant's judicial protection, is not automatic nor limited. The administration must carry out a balancing of the interests at stake, meaning the access that access to such information must not distort competition in future procurement procedures. So the principle is that prohibition on disclosing confidential information must be balanced with judicial protection. And Article 39 provides and allows such balancing. National rules cannot impose unconditional access. So the conclusion is that Article 39 precludes legislation granting automatic access to trade secrets for judicial defense without enabling a balancing by contracting authorities. And impact in Italy was high because defensive access is not so automatic or unlimited, and the authority must conduct a concrete balancing test, verifying indispensability and necessity, avoid undue disclosure that may distort competition, and provide specific reasoning for denial or limitation. I hope that everything was clear, maybe a little bit technical in the last part of the lesson, as I am a lawyer, and I really think that through the examples and the case law, also because the Court of Justice has a great importance in the interpretation of the union law that follow the practice, it is important to understand the reason of the regulation and to be really acknowledged about what is, for instance, in this case, the right of access to documents, and what I can do as a citizen or as a chief of an enterprise or whatever. So I hope that this lecture has been clear, and see you in next session for the conclusion of this module on citizen democratic participation in the Union.